I'm Amanda Moore, Director of the Clearinghouse Community at the Sargent Shriver National Center on Poverty Law. Today's webinar is brought to you by the Shriver Center, a national leader in advancing justice and opportunity, and the National Housing Law Project, a national housing and legal advocacy center that works to advance housing justice. Before we get into the webinar, I'd like to take care of a few housekeeping matters. I expect that several of you will have questions for the presenters today. We welcome those questions and we invite you to submit them to us. Just for a second, I'll interrupt myself and ask if everyone could put themselves on mute real quick. I think maybe all of our attendees are on mute. Okay, great. I just want everyone to be able to hear all this important information. So I expect that several of you do have questions for the presenters today. We welcome those questions and we invite you to submit them to us through the question panel, which is in your GoToWebinar control panel. And I'll go ahead and answer a couple of questions now that always come up during our webinars. First, yes, this webinar will be recorded. We'll send out a follow-up email within a few days to everyone who registered for the webinar, and that email will contain a link to a page where you'll find the webinar recording, a copy of the slides, and links to some additional resources. Second, for attorneys in California only, today's webinar offers NCLE credit. If you are a California attorney and you would like to receive NCLE credit for your participation in today's webinar, please email Deborah Thrope directly. Her email address is dthrope, D-T-H-R-O-P-E, @nhlp.org. Now, her email address will also be in the follow-up email that you get, and it's on the last slide of today's presentation. So if you didn't get that written down when I said it, there'll be another chance. And we know that some of you like to tweet during webinars and other events. If you plan to do so during today's webinar, we ask that you use the hashtag #reentryhousing. There it is on your screen. This will help us follow the conversation, and we invite you to follow along too. You can also tag the Shriver Center and the National Housing Law Project that's @Shriver Center and @NHLP. I'd now like to introduce our presenters for today, Deborah Thrope and Marie-Claire Tranley-Young. I'll start with Deborah. Deborah Thrope is a staff attorney at the National Housing Law Project. Her work focuses on policy advocacy to preserve federally subsidized housing and tenants' rights. She collaborates with national policy leaders to develop strategies for housing the most vulnerable populations, including chronically homeless adults, people with disabilities, and previously incarcerated individuals. She's assisted a range of housing providers in developing policies responsive to the needs of the reentry community. She's currently updating an Affordable Home on Reentry, which is the National Housing Law Project's signature field manual on barriers to federally subsidized housing faced by people with criminal records. And now to Marie-Claire. Marie-Claire Tranley-Young is a staff attorney in the Housing Justice Unit at the Shriver Center. Her work is focused on housing and criminal records, especially increasing the use of the Fair Housing Act to challenge unreasonable criminal records policies. This work arose from a Soros Justice Fellowship that she received in 2010. She most recently authored When Discretion Means Denial, a National Perspective on Criminal Records in Federally Subsidized Housing, which was published by the Shriver Center last year. A link to this report will be included on the website with the recording of this webinar. So now, Marie-Claire and Deborah, I'll turn it over to you.
Thanks, Amanda. Thank you, everyone, for being here with us today. We're very glad to have everyone, especially after the webinar we had last month. I'm going to go through, this is Marie-Claire, for those of you who don't know my voice yet. I'm going to go through a quick overview of the webinar for today. First, we're going to do a summary of HUD policies on the use of criminal records. And that's going to include a very brief summary of admissions and terminations policies for HUD subsidized properties with respect to criminal records. After that, we'll move into an overview of the HUD Guidance, 2 HUD Guidances that came out in November and in April. And that overview will include a discussion of fair housing protection, the use of arrest records, the use of mitigating circumstances, due process protections, and lookback periods. After that, we'll talk about advocacy strategies. And Deborah and I today really wanted this to be practical for advocates and people looking to change policies in their local jurisdiction. So we're going to walk you through comments on sample PHA plans. And then that'll be followed by a question and answer session where we really want to hear questions from the audience on issues that they're seeing and really make this as practical as possible. Now, before we get into the meat of the webinar, we want to talk a little bit about why now. Why is this issue of criminal records and housing seem to be gaining some momentum? And first, I think, one of the things that we have seen in the last year or so is a national discussion on criminal justice reform and a renewed interest in looking at how do we end mass incarceration. We have President Obama who's doing his small part, but still an important part in commuting sentences. And the people whose sentences have been commuted, as well as all the people who are coming home from the criminal justice system, have a need for housing stability as they re-enter. Also nationally happening is the Federal Interagency Reentry Council, which is doing work to bring attention to these issues and did a lot of work last month during National Reentry Week to really bring to light the issue that people face when they're trying to come home.
Great, thanks Marie-Claire. And this is Deborah. So each year in the U.S., over 680,000 people are released from prisons. They're routinely barred from both private and subsidized housing. So even when they're not categorically excluded, these folks must compete for affordable housing with the 46.7 million other Americans who live at or below the federal poverty level. So the need for subsidized housing and affordable housing, of course, far surpasses the amount that's available, which makes it all the more important for advocates to be familiar with applicants' and tenants' rights during the application, termination, and eviction process when it comes to criminal activity. So with that, we're going to start our presentation. As Marie-Claire said in the introduction, we're going to kick it off with a very brief summary of admissions, evictions, and termination policies for HUD subsidized properties regarding criminal records. So we are going to focus on the big HUD subsidized programs, public housing, housing choice vouchers, and project-based Section 8. So just keep in mind during this discussion, we're talking about those programs. We are not going to get into a discussion of some of the smaller HUD programs, such as HOPWA, which is Housing Opportunities for Persons with HIV/AIDS, and the Continuum of Care. And just note that there are fewer restrictions generally in some of those smaller HUD programs, particularly aimed at housing people that have been homeless. And so just on one other note, we're going to, as we concentrate on the large HUD programs, I just also want to say that we're not going to discuss tax credit buildings. So as opposed to the HUD programs, there's actually a notable lack of standards for tax credit buildings, and none of the restrictions that we talk about today are going to apply for those buildings unless, of course, there's a HUD subsidy attached. So let's start by talking about mandatory bans. There are only a handful of mandatory bans in HUD subsidized housing based on criminal history. So there's only 2 permanent bans, as it says here. First one is a conviction for manufacturing methamphetamines on the premises of a federally assisted housing property. And the other permanent ban is for lifetime registered sex offenders. So note that those 2 bans are very specific and that the tenant or applicant has to meet the specific criteria in order to fall into one of these categorical bans. So for example, as it says here, the lifetime registration for sex offense ban, that would only apply to a lifetime registrant. So some states have registries that might be only for a shorter period of time, for example, 2 years. an individual could be obligated to be on the registry. So this ban would only apply to lifetime registrants. So it's important to know the rules on that in your state. So along with the two permanent lifetime bans, there's also two temporary bans for federally subsidized properties. One is current users of illegal drugs, abusers of alcohol, or a pattern of interfering with the health, safety, peaceful enjoyment, or anyone who within the last 3 years has been evicted from federal housing for drug-related criminal activity, and there's a couple of exceptions to that. Note for these temporary bans, the language is also very specific. So in a vast majority of cases, housing authorities are going to have discretion to consider whether to deny, terminate, or evict an applicant or tenant. But note the discretion is limited in some very important ways. So public housing authorities and owners may consider denying admission, evicting, or terminating for drug-related criminal activity, violent criminal activity, or other criminal activity that would adversely affect the health, safety, or right to peaceful enjoyment of the premises by other residents, owner, or public housing employees. So while this is relatively broad, even HUD has said that there are a wide variety of other crimes that cannot be claimed to adversely affect the health, safety, or welfare of the PHA's residents. And advocates have argued, oftentimes successfully, that applicants, for example, shouldn't be denied housing for criminal activity, or such things as shoplifting or littering, and even driving while under the influence. It's also important to note that any policy by the PHA has to be in writing and available to applicants and tenants. There's two additional limits on housing authorities or owners' discretion when it comes to an adverse action based on criminal history. And we are going to talk about these two limits in greater detail in the presentation. But one is civil rights laws, including the Federal Fair Housing Act, and two is time. So any criminal activity that's a basis for an adverse action must must have occurred during a reasonable time. And so we call that reasonable time before the screening takes place a look-back period. So housing authorities and owners must have reasonable look-back periods.
Okay, so now we're going to go over the HUD guidance. A lot of you are probably familiar with this, so I'm just going to go through the notices quickly, and then we're going to do a deeper look at the issues that they raise. And there's a lot of overlap between the different notices. So the first is HUD, well, we refer to it generally as the arrest record guidance. It's HUD Notice PIH 2015-19 and Housing 2015-10. And this is from the Offices of Public Indian and Indian Housing and the Offices of Housing, and they apply generally to public housing, vouchers, and multifamily housing. That was released in November, and in March, HUD released a subsequent frequently asked questions document that was supposed to answer certain questions that they had been receiving in the field offices from PHAs. In April, we received the HUD Fair Housing Guidance, which was issued from HUD's Office of General Counsel, and it discusses the application of Fair Housing Act standards to the use of criminal records by providers of housing and real estate-related transactions. This is much broader than the November guidance. It is not limited to subsidized housing. Rather, it covers the entire rental market and has a lot of, it basically covers all the housing that is covered by the Fair Housing Act. HUD has said that an FAQ is forthcoming, though there's no immediate date on when that document will be released. So, the first big area that we want to talk about is the fair housing issue, and particularly the issues that come up under the Fair Housing Guidance. And generally what we know is that criminal record status is not one of the protected classes. Protected classes we usually think of as race, national origin, and under the Fair Housing Act, familial status. But criminal records is not one of them. But what the Fair Housing Guidance did was it told, it gave HUD position that adverse housing decisions based on a person's criminal record may violate the Fair Housing Act, which prohibits discrimination on the basis of race. And this has been something that advocates have been noting for a while, and the fact that HUD similarly interprets the Fair Housing Act, which it is charged with enforcing in a similar way, is very hopeful for people with criminal records to access housing. So for subsidized housing, as Deborah mentioned, this becomes a significant limit on the discretion that PHAs and project owners enjoy. And it also, as people may have seen, gets the attention of a lot of the private landlords that had not necessarily been interpreting the Fair Housing Act in this way. And so it's a good idea for us to sort of talk through what this document says. And there's two main ways to make a case that a criminal record screening policy violates the Fair Housing Act. The first way is discriminatory treatment. And under discriminatory treatment, the housing provider applies its policy inconsistently. And because it applies inconsistently, it often becomes a pretext for race. So for example, if you have a landlord that's doing criminal background checks only for African American applicants and not for others, then it seems then the inconsistent application of this policy is intentional discrimination. So that's a case that is probably a little bit easier to prove. The second way to make a case is under the disparate impact theory. And essentially under the disparate impact theory, you have a facially neutral policy, which in this case would be the criminal background check policy, that has unjustified disparate impact on racial minorities. And that disparate impact is not justified by a legitimate reason. So in these cases, there's usually three steps. So the first step is usually you have the question of, is there a disparate impact on race or other protected class? Usually this is the burden. The burden to make this case is usually on the applicant or the plaintiff in this case, and usually use statistics. So what HUD has said is that local and state statistics are preferred, but national statistics may also work. So if you look nationally, you see that there is definite racial and ethnic disparities in incarceration across the nation, both in the prisons and in the jails. And that could be part of a case. It probably is not enough to make a whole case, but that could be part of a case for showing why a criminal records policy has a disparate impact on race. So then the next question is that disparate impact justified? So in other words, is the policy necessary to achieve a substantial and legitimate and non-discriminatory interest? This will be the housing provider's burden. And one thing that's very important here is that the HUD says you really need to have proof. You can't just speculate that, having a criminal record policy will make your development safer, because we need much more than that to be able to have a policy that disparately impacts racial minorities. And the defendant has to show, the important language is that they have to show that the criminal activity that's being prohibited indicates a demonstrable risk to resident safety and or property. So what does that mean? So I mean, that second part, I think there are some general principles that we can get from that second requirement. Number one is that if you have any sort of policy where you are allowed to deny people who have arrest without conviction, that's not going to fly, because arrests by themselves without any sort of conviction don't have proof of criminal activity. They're just proof that somebody suspected you of criminal activity. The second general principle is that blanket bans based on convictions, on all convictions, is not going to be okay, because you cannot say that any conviction indicates a risk to resident safety and or property. So you don't have that real proof that you need. And then the last principle is that even if a policy only refers to some convictions, the defendant still has to show that there's that risk. And what the guidance says is that you can show it by showing that the housing provider considered the nature, the severity, and the recency of the criminal activity. And finally, if you get to the last part of the case, then the burden falls back on the applicant to show, is there a less discriminatory alternative? And usually what HUD says is that an individualized assessment and mitigating factors will usually be less discriminatory alternative to a blanket ban. So we don't just eliminate everybody who has a felony conviction, but we try to figure out, okay, does this person have mitigating factors to really show that they can be a good tenant. Now, one big exception, and this is a very big exception, is that you can't really have disparate impact claims under the Fair Housing Act for convictions for manufacturing and distributing drugs. This is a limited exception. You can show, for example, that a housing provider is intentionally using these type of drug manufacturing and distributing convictions against African Americans and not white applicants. But if you're just trying to show that it has a disparate impact on race, then these convictions don't get relief under the disparate impact theory.
So, Marie-Claire, let me ask you, why do you think there's this big exception for convictions for manufacturing and distribution of drugs?
I think that it probably is a relic of the war on drugs. I think that the exception came about sometime in the 90s, and I think it came along with a lot of other restrictions that were placed on benefits around that time, and it was all around trying to get people, or trying to punish people who are convicted of drugs. So hopefully it'll lead to, given the national conversation on criminal justice reform and how maybe we have erred in that, on that war of drugs, maybe there will be an opportunity to revisit this very large exception.
Right. And I think that's true of all of the policies, the tenant screening policies, and the HUD regulations certainly are remnants of the war on drugs generally as well. So I agree and hope that we'll see some changes in that soon. So now we're going to move on to another really important part of the new HUD notices. Thank you so much, Marie-Claire, for that excellent overview of the fair housing implications. We're going to move on from the fair housing notice and talk a little bit more about HUD Notice 2015-19. That was the November notice that had a lot of important guidance from HUD. Notably, the notice talks about the use of arrests in as a basis for adverse actions in HUD subsidized housing. So whereas the fair housing guidance focuses on, it applies to all housing providers, the November HUD notice really applies to subsidized housing providers. And the notice is very clear that arrest alone cannot be the basis of a denial or a denial of an application or eviction or termination. Arrests represent a mere suspicion of criminal activity and are not proof of criminal activity. So that leaves us with the question: if housing providers cannot rely on arrests
arrest alone when denying an applicant or for an eviction or termination, what can they rely on? What is proof of criminal activity? So in the notices, HUD said that arrest can be a starting point for an investigation. So arrest alone, again, can't be the basis for an adverse action, but could be the starting point for some type of investigation when considering an application or whether to terminate or evict. The guidance talks about other types of evidence that could be used as a basis for an adverse action, including police reports detailing circumstances of an arrest, witness statements, and other relevant evidence. But an important note here is that there are due process concerns, and later on in the presentation, we're actually going to talk a little bit more detail about those due process concerns. But these are all different types of evidence that housing providers could potentially rely on. It's important to note that the standard, though, that housing providers should use is a preponderance of evidence. So basically, no matter what evidence is presented, it must be more likely than not that the individual engaged in criminal activity.
So Deborah, one question that we've heard a lot, I think, both from the public housing authorities and also from advocates, is the issue of pending arrest. So we know that an arrest, like a historical arrest where it didn't result in a conviction, shouldn't be used. But what if somebody comes in and they have a pending arrest?
Right. So similar to an arrest, the pending arrest alone really couldn't be the basis of an adverse action, although the FAQ that HUD published following November's notice explicitly does state that the PHA or project owner can move forward with an adverse housing decision if there is a pending arrest. HUD also states, though, that it may be advisable to wait until the disposition of that pending arrest, but PHAs and owners do have discretion to use available evidence to make an eligibility determination according to its policies. So that would include the evidence surrounding a pending arrest, which leads me to another important question that we've received a lot, which is a question about warrants. So can warrants be used as a basis for an adverse action? And warrants are not explicitly mentioned in the HUD notice, and if I would argue that if arrest alone can't be the basis of an adverse action, neither should most warrants. So I think it's important for advocates to consider the underlying criminal activity that the warrant is based on. So, for example, I'm based in California. In California, you can receive a warrant if you don't pay fees associated with a traffic violation, for example, or for quality of life crimes associated with being homeless. So it would be important to look at the underlying basis of the arrest that the warrant is based on in order to make that determination. And just like we do with arrests, argue that it couldn't be the basis of the denial of the adverse action, the denial, eviction, or termination. But of course, housing authorities and owners may choose to use evidence surrounding the warrant as a proof of criminal activity. So overall, I think that it's important to remember that as a best practice, housing providers should really only be using conviction records. The guidance from HUD makes it very clear that conviction records really are the most solid basis on which to make an adverse determination relating to criminal records.
Thanks, Deborah. So we've talked about the Fair Housing Guidance and we've talked about arrest. Another big topic that comes up is the issue of mitigating circumstances. And this is important for a lot of people because they may have a conviction, prior conviction on their record, but maybe in the time since they've come out, they've done a number of things to show that they are more than their criminal record. And so if you look generally at the public housing programs, public housing authorities are required to consider mitigating circumstances for public housing admission. For the other programs, notably Project-Based Section 8 and the Housing Choice Voucher Program, those mitigating circumstances may be considered, but they're not explicitly required by regulation. I know that in some cases, I think some courts may have taken another position, but I think when you're representing a client in front of a housing provider, one thing to note is that the regulations do state that before an adverse action, an applicant or resident must have the right to dispute the relevance of a criminal record. Usually you see that in terms of, it also, the language of the statute also says accuracy, but a lot of times people say, well, this wasn't me, this is somebody else. But the language of the regs also say that you can dispute the relevance, and that might be one way to get in there this issue of, well, this is no longer relevant because of these different mitigating factors. Another piece of information that argument that you might want to make to the housing provider is, again, that HUD emphasized in its notices that one strike is not required in subsidized housing. So we would have liked HUD to take a much stronger stance against one strike and just altogether eliminate it. But it did say that it's not required and that PHAs and project owners have discretion. And so, again, we urge housing providers to exercise their discretion in favor of admitting people who have mitigating circumstances. So that's another argument to make. And I think also the Fair Housing Guidance provides a really good tool for arguing that the housing provider should always be considering mitigating circumstances. And that's because, again, as I mentioned before, it talks about trying to requiring housing providers to show a demonstrable link to resident safety and or property. And I think that if an applicant or a resident who's facing termination or eviction can show that this criminal history or criminal record doesn't really have a link to safety and to resident safety, I think that that can be a potentially powerful tool to get in these arguments about mitigating circumstances. And do we have, and then Deborah's going to kind of walk through some of the examples of mitigating circumstances that we have from the notices.
Great. So the notices, as Marie-Claire said, do provide some great examples of mitigating circumstances that housing providers could and should consider in making their admissions in the evictions and termination decisions. So first notice, the November notice, 2015-19 from HUD, talks about, as an example, the following mitigating circumstances. Whether the applicant's offense bears a relationship to the safety and security of other residents, the level of violence, if any, of the offense for which the applicant was convicted, the length of time since the conviction, so again, the look-back period, the number of convictions that appear on the applicant's criminal history, if the applicant is now in recovery for an addiction, whether the applicant was under the influence of alcohol or illegal drugs at the time of the offense, and any rehabilitation efforts undertaken by the applicant. And those pertain specifically to the admissions context. The same notice also talks about mitigating circumstances in the eviction context, including seriousness of the offending action, effect that the eviction had on the entire household, would have on family members not involved in the criminal activity, the extent to which the leaseholder has taken all reasonable steps to prevent or mitigate the criminal activity. Those are just a few examples. And as Marie-Claire mentioned, the Fair Housing Guidance provides some really good language on that. And it includes examples of mitigating circumstances as well, including the facts or circumstances surrounding the criminal conduct, the age of the individual at the time of the conduct, evidence that the individual maintained a good tenant history before or after criminal conduct, and evidence of rehabilitation efforts. So I think there are a lot of themes that we can see with these notices from HUD on evidence of mitigating circumstances. So one is, of course, evidence of rehabilitation. So it's a really important thing to present to a housing provider on behalf of a client. It's also the seriousness of the action itself. So any mitigating circumstances about the underlying criminal activity, and then the length of time since the offense or the look-back period. And of course, there are other host of other mitigating circumstances that advocates can present on behalf of their clients. So next, we're going to talk a bit about disabilities and mitigating circumstance. So if you are working with an applicant or tenant and the underlying criminal activity is related to the individual's disability, the advocate can make a request for a reasonable accommodation to the housing provider, and that they make an exception to their tenant screening policies because it's necessary as a result of the tenant's disability. Advocates should always make this reasonable accommodation request if that is the case. There's really an independent basis, aside from arguing that the housing provider should consider mitigating circumstances. The independent basis for that request is really additional protections under the Fair Housing Law. So for all housing providers, that would be the Fair Housing Act. When we're talking about federally subsidized housing, it would be Section 504 of the Rehabilitation Act and or the Americans with Disabilities Act could all apply and require the housing provider to provide a reasonable accommodation for a tenant whose criminal activity is in fact related to their disability. So I'll just provide a quick example of that. If you're working with a tenant who perhaps is on psychiatric medication, experiences a mental health disability, and goes off their medication for a short time, and in that short time is arrested and convicted of criminal activity, the housing provider might in turn try and evict that tenant based on that criminal activity. And there are protections under the Fair Housing Act that would allow that tenant to request a reasonable accommodation because the criminal activity is directly related to that individual's mental health disability. And HUD's guidance falls short in this area, and we're going to talk a little bit later in the presentation about a little bit more detail about how HUD's guidance really does not discuss at all the fair housing protections specifically available to people with disabilities that have a criminal history. So the HUD guidance doesn't speak to this, but it's important to note that if you're working with a tenant or an applicant with a disability, that the accommodation should be requested, and it should be considered as a mitigating circumstance, the disability, the criminal activity that's related to disability. So there are some cases on this. Interestingly, the case law on this particular issue is mixed. There's not a ton out there, and the cases tend to come out more favorably towards tenants in termination and eviction cases as opposed to on the application side. So there's some good cases out there where tenants have requested the accommodation because in an eviction context or termination context when the criminal activity is related to their disability and have been allowed to remain housed, asking for an exception to the housing provider's termination policy. But the cases on application side don't fare as well for the applicants that in their past have had some arrest or conviction that's related to their disability. And I think there are a couple of reasons for that. One is it's very difficult for courts. Courts will say having a criminal record is not a protected class. So of course, the counter argument is it's the disability that's a protected class, not the fact that an individual has a criminal record. But courts have certainly made that argument. And the other issue deals with current drug use, where current drug use is where there's current drug evidence of current drug use at the time of the criminal activity, that can get a little bit sticky with fair housing laws as well, because current drug use is not considered a disability for purposes of protection under fair housing laws. So just know that those are a couple of complicated and emerging issues when it comes to arguing that disability, the housing providers are required to consider disability as a reasonable accommodation in mitigating circumstances in the application or termination process.
So thanks Deborah, another area where we often urge people to consider arguing mitigating circumstances is when using the Violence Against Women Act, which provides protections for survivors of domestic violence and sexual assault and other crimes. And so usually when this comes up, this can come up in a lot of different ways. What we have seen often is sometimes there will be a situation of abuse, and the police may arrest both the perpetrator and the survivor. And then so both of them have a criminal record as a result of this interaction. And so what is usually useful, or what has been useful in the past, is to inform the housing provider of the circumstances of the situation and give them a sense of what happened that's beyond what is sort of in the police report or on the arrest record. So that's an important mitigating circumstance to give to housing providers.
Great. So Marie Claire and I discussed this at length before the webinar, and we really wanted to present as the best circumstances regarding mitigating circumstances, the opportunity to present mitigating circumstances before an adverse action. So that would mean in the application process, for example, allowing an applicant to present those circumstances along with evidence of criminal activity.
And so I think when we talk about that, we also have to sort of think about the growing movement. And I'm going to switch slides out here and get an application, a housing application. There's a growing movement. Well, there is an established movement in the employment sector to ban the box, which is essentially to remove criminal history questions from initial applications and to save the criminal history review until later in the process, after a person has done an interview and after the employer has been able to get to know the applicant and their qualifications and the whole person. And so because of the success, I think, of ban the box in employment, there have been some interest to ban the box in housing. And so I think that when you look at what I have here on the screen is a application from a housing authority. I think it might be in Florida, and it has an entire page of questions about a person's criminal record. And in some ways, ban the box is going to be helpful because I think that most people, the criminal justice system is sort of like its own bureaucracy, and there's a lot of different types of dispositions and a lot of different hurdles you have to jump over to maybe satisfy probation. A lot of different things that I think clients might not be able to always be able to report 100% accurately. And so ban the box would be helpful in this area because you would eliminate this type of problem. And I think one of the problems with an application like this is that there's just so much room for inaccuracies from the client, which the public housing authority could then ding the client for having made a fraudulent application. And so in that way, Ban the Box is helpful because they sort of take that that predicament away from the applicant, and also it sort of removes the criminal history from the initial grounds. But Deborah, I think we've also think that maybe there might be some inconsistencies between having Ban the Box and putting mitigating circumstances first.
Yeah, so I think that's right. I think the Ban the Box in housing policy can be a bit problematic for a couple of different reasons. So one is it really doesn't account for the wait times in housing to get the criminal record. So I think it works a little bit differently than in employment, where the job is just available, whereas for housing, there can be a little bit more of a wait time. Plus, I think with housing, it really makes a big difference to get the housing provider to consider those mitigating circumstances up front and be part of the holistic application. So there's definitely inconsistencies in us saying, a best practice is to consider the mitigating circumstances up front, although some local jurisdictions are in the process of adopting or have adopted a Ban the Box in housing policy. I will speak to briefly the San Francisco policy, which is one of several, very few though in the country that it does have a Ban the Box and housing element. It can be quite powerful. The policy applies to affordable housing providers, and so there has been a reaction from some of those housing providers that the policy has frustrated a bit their tenant screening procedures. But of course, that would be, it really would be a local decision. So that might not be the case in some other areas. And from what we've heard from some advocates, that these policies that Marie-Claire just put on the screens, that policies like that are really one of the largest impediments to people with criminal histories getting housing, because they don't, they just assume not even bother apply. So they never even get to the application stage. So Ban the Box, of course, would be quite beneficial, and as Marie-Claire said, in getting rid of some of those forms. But the flip side is, if you're regulating affordable housing providers, it might create some additional challenges for those folks. So we don't have a right answer to this. We're suggesting a best practice as far as presenting mitigating circumstances goes, but we also recognize that it's really a local decision, and there's no right answer on this issue. And it's, again, a very emerging area, and it's something that we can continue the discussion and hearing to see how this is implemented on the ground.
Yeah, it would be great to hear from other people about this issue.
Great, thanks. So I think Marie-Claire, you're going to move on to some due process rights.
Yeah, so I'll quickly go through this. I think for both admissions and termination and eviction, there is a general right to notice of the impending action and an opportunity to dispute the accuracy, as I mentioned before, the accuracy of the criminal record and the relevancy of the criminal record. Before admissions, there's a request to an informal review after the denial, and in the termination and eviction section, there is a right to administrative hearing before an impartial hearing officer. In some states where there's a due process determination, people may not have this right. In the eviction area, which is a cause of concern for some advocates, but we are definitely trying to get in HUD's attention. And so Deborah's going to go through the different issues that come up under these due process rights.
Great, thanks. So the HUD Notice, as Marie-Claire said, reiterates the right to due process. And the November Notice does mention an applicant and tenant's right to be represented by counsel, to question witnesses and refute evidence presented by the housing provider, but it doesn't specifically talk to the evidence itself and the reliability of it. So we just wanted to remind advocates to dispute unreliable evidence, and especially hearsay issues at any type of hearing. The judicial rules of evidence don't apply in informal and administrative hearings, but nonetheless, advocates should consider whether the evidence presented by the housing provider should be used to support the decision. And as I said, hearsay issues are, it's important to just remember that there are hearsay issues and to be sure to think about the reliability of the evidence that's used to support any adverse decision.
Yeah, so I think one thing that we've heard definitely from advocates and also from some housing providers is that, you know, this idea that you can not use arrest records, but you can use police reports or witness statements might have its own issues. Could you speak to that, Deborah?
Sure. It's a really good question because these notices do speak to all these other forms of evidence that presumably can be used to support or denial or termination. So advocates should, again, always challenge the use of this evidence, especially if there's no opportunity to cross-examine. So the police report, if the police is not at the hearing to testify to the report, that piece of evidence should be challenged, similar to witness statements. So if the witness is not at the hearing, then again, the statement should be challenged if it's used as a basis for the adverse action. And I do think the FAQs published by HUD as a follow-up to the November notice, I think it's problematic for this reason because, again, it states that PHAs and owners can consider police reports and witness statements and other evidence to, you know, as relevant to whether the applicant or tenant engage in the activity. So it's true, while the housing authority and owners may consider the evidence, they should be very careful in basing the decision on it. And the hearing officers really should consider the reliability and probative value of any hearsay evidence when deciding its weight at that informal hearing. State law does vary a bit as to the use of hearsay in administrative hearings, so advocates should just become familiar with the rules in their state regarding the evidence. And there are a host of cases on this issue, particularly in the voucher termination context, that you could also argue apply in other contexts. And courts have addressed due process issues of using hearsay, as I said, mostly in voucher termination hearings. So I think, Marie-Claire, we've talked a lot about what is in the new notices from HUD and the new guidance. And I think now what we'll do is maybe turn to what the notices fail to do.
Okay, so there's two main open questions that we've seen in these guidances. Number one is this idea is what is a reasonable look-back period? Earlier, Deborah had mentioned that the regulations and the law say that housing providers or PHAs and project owners are limited to looking at criminal activity that occurred within a reasonable time before the admissions decision. And so what is reasonable has been a question that people have been grappling with for a long time. I think advocates, housing providers, and HUD itself has been grappling with this issue, and there's still no definitive answer from HUD. Some people we've talked to has noticed that HUD had referred to a study in the Fair Housing Guidance that may have suggested or may suggest that 7 years might be a reasonable time period, but we really caution against using that time period because data is actually longer than a lot of different like PHAs have. Granted, I think maybe on the private rental market that might be on the shorter side, but I think we might be taking a step back if what we're asking for is in the 7-year range across the board. And so in the absence of definitive guidance, we look towards guideposts. And one of the things that we note, the Shriver Center made a report last year. We looked at over 300 public housing authority and project-based admissions policies, and we have an appendix in there of a lot of the different look-back periods because that's a big question that people have been asking. But information might be a little bit dated only because it did take place, a lot of that took place maybe 2 or 3 years ago, but it still gives a snapshot of what public housing authorities had in terms of their look-back periods. And while there are some really egregious ones that we point out, if you look at it, a lot of people fall within the 3 to 5 year range. And 5 years, I think, came from the fact that HUD at one point had said that 5 years might be okay for serious criminal activity. So I think we want to as advocates maybe try not to go above the 5 years and see if there's a way to move it down, because it just 7 years just sounds so long for people, especially after they're coming home. The other important guidepost is if you look at the notice from November, HUD has a list of best practices that it offered in lieu of maybe giving definitive guidance on certain issues. And one of them, they noted that there was a housing authority that had 12 months for drug-related criminal activity and 24 months for violent criminal activity. So again, it's not definitive HUD, stating this is what a reasonable look-back period is, but they thought enough about it that they put it in this document. And so that's something that I think advocates will continue to have to work with, especially for PHAs, a lot of whom now still have 10-year look-back periods and longer in some cases. The second open issue that Deborah mentioned is how do the fair housing laws protect people with disabilities who have come in contact with the criminal justice system? There is definitely an argument to be made that people with disabilities, especially people with mental disabilities, are much more involved in the criminal justice system than their numbers in the general population. And so I think that there's definitely a disparate impact argument to be made. The difficult part here is just collecting data on this. And this is sort of like an open question, I think, for advocates as we move forward and sort of in this next area, like how do we get data, especially given that, disability is something that sometimes you have to self-report. People don't necessarily, maybe people are not diagnosed yet with disabilities. So there's a lot of issues that arise out of data. So we wanted to flag that. So now I think that we've gone over this guidance, the guidances, we want to spend some time talking about how to advocate for good local policy. I think Deborah will start us off on that.
Great, thanks. So as Marie-Claire said, we're going to jump into a real practical approach to changing tenant screening policies. We're going to focus on local public housing authority plans, which must comply with all of these notices. So those include administrative plans for the voucher program and the ACOP, which is for the public housing program. The HUD notices explicitly state in the FAQ notice that a PHA may need to amend their policy with respect to criminal records based on the new guidance issued by HUD. So I think it's a really great time for advocates to take a close look at your local housing authorities' plans regarding tenant screening and eviction policies based on criminal records, because the plans not only must they reflect the notices, but There's just a lot of buzz around this issue right now. I mean, you know, as Claire said in the introduction, there's a national focus on these issues. So it just presents a really great opportunity for advocates to comment on these plans. Now, the housing authorities that I've spoken to have chosen to wait until the next annual plan process to potentially revise their screening procedures and their eviction policies based on these notices. That might not be probably not the case for all housing authorities, but for a lot of them, I would guess that they're just going to wait until the next annual plan process rolls around, which would provide an opportunity for notice and comment, of course, but there's no reason why advocates couldn't start the process, the comment process now, and reach out to housing authorities.
Yeah, and I think that there's also another really great opportunity, which is the to the affirmatively furthering fair housing process that is rolling out across the country. There's the community participation process, where there is jurisdictions are supposed to go through an assessment of fair housing obligations, and it becomes a good venue for raising issues about whether there's discrimination against people with criminal records and the formerly incarcerated, whether that occurs in the public subsidized housing programs or even on the private rental market, whether they're impacting members of protected classes, such as race or national origin or disabilities, which is what we've talked about here. And then as part of that process, the jurisdiction, which may include the PHA, will have to consider those comments. And so again, it is similar to the PHA plan. It's kind of coming together and working, most probably in coalition with other organizations to really highlight these fair housing impediments for people with records.
Great, and it is. Sorry, I was just going to say, we look in, the draft tools that HUD has put out for this process, and identifying the fair housing issues related to people with criminal records is, in fact, in the tools. And so, as Claire said, it provides a really important opportunity to identify those issues and work with the community to eliminate those barriers.
Mm-hmm. So, when you're looking at local PHA plans and going through the AFH process, what is it that you're looking for? So common issues, and these are not exhaustive, but these are just common issues that we see. Number one, definitely are housing providers using arrest. That's pretty easy to spot, though HUD has muddied the waters a little bit by saying that you can include it as part of the investigation. You still want to look critically at the use of arrest. So another thing they look at is, are there very long look-back periods? Is there any look-back period? Are they allowed to look back whenever? Are there blanket bans that ban anyone with a criminal record, anyone with a felony record? Are there very overbroad categories of criminal activity? And we'll have examples of this in a little bit. And then, are there due process rights? So there's a lot of things that you can look at in a PHA plan or in an admissions policy that you can make comments about in the PHA and AFH process. And so Deborah and I are definitely here to help advocates who undergo this process because we are seeing a lot of these issues come up, and we really want to make sure, especially, HUD has rolled out these guidances, but we're not exactly sure where they are in implementation, so I think it's also on us as advocates to really stress that these guidances are out there, and when they do not, when PHAs and other project owners don't comply, then we need to bring that HUD's attention to it because I think that they're kind of looking at advocates to play that role. So now we're going to move to examples of bad policies, which is the fun part for us, I think.
And
I think Deborah will take the first one.
Thank you. And I should add that these are real policies. So we identified, it wasn't that hard to do so, unfortunately, but policies from a couple of housing authorities around the country that we've identified as as bad policies that might contradict some of what HUD has, some of the HUD guidance. So we'll jump right in. So I'm going to read this piece out loud, and then we'll talk a little bit about how we might comment on this. So this particular policy says staff will determine if the applicant has a history of disturbance to neighbors, destruction of property, or living or housekeeping habits at prior or present residences, which may adversely affect the health, safety, or welfare of other tenants or neighbors, or a criminal history activity on the part of any applicant member involving crimes of physical violence to persons or property, or other criminal acts which may affect the health, safety, or welfare of other persons. And then it lists a couple of examples of other criminal acts, but it says it is not limited to. So those would be the grounds for denial. So we're going to break down this policy a little bit and talk about some of the issues we see. I mean, on first glance, it certainly does feel very broad. It seems like this is quite all-encompassing of somebody's prior criminal activity. So just that alone, and this is quite common from what we see in a lot of these policies, just, you know, sort of knee-jerk reaction is this covers a lot of stuff. So specifically, there's no time limit here. So there's no look-back period. The grounds for denial could be, you know, any of these criminal acts, any time in history. And as we discussed, the reasonable look-back periods are, in fact, required. So without some look-back period here, I would certainly comment on the fact that this is just, you know, this goes back forever in time, which would be not permitted under HUD's rules. So I think a couple of other issues are the use of arrest to prove criminal activity. So clearly the other criminal acts may include but are not limited to a pattern of arrest. So that's essentially telling the housing authority that an arrest could in fact be evidence of criminal activity and the basis for an adverse action. So I think that's also too broad. There's no due process protection stated here. So there's no requirement that the PHA provide the criminal record to the applicant, for example. The applicant wouldn't be on notice of what the denial or the adverse action was based on. And so, you know, generally, as I said, this is a very broad policy, and this is just a piece of it, but these grounds alone are quite, for a denial, would be quite problematic. And I think we have another policy for you, which is we're throwing someone under the bus here, but that's okay.
So this is another policy that we found, and it allows the housing authority to document, and we look through. I mean, we look through the whole policy, so we're not just cherry picking here. I mean, there isn't something else in the policy that we just overlooked. We look through the whole policy. So this allows the representative of the housing authority to document any pertinent information, and one of them is regarding criminal activity, and it just the entire policy, it talks about criminal activity. It includes the criminal activity that is mentioned before, mentioned in latter pages, but nowhere is there really a limit on what type of criminal activity can be used. And so, you know, we think that probably is blanket ban. Obviously, the way people apply these policies is another question that we need to figure out. But right now, this allows the housing authority to deny anyone with criminal activity, and that type of language chills people's desire to submit applications, and which is why there's such a prevalent myth out there about the inavailability of federally subsidized housing for people with records. This third point is sort of interesting because it talks about several violations of federal, state, or local law, so any law whatsoever, that indicates disregard for the law or the rights of others. those are very, very broad statements, and they also go on to talk about trespassing, disturbing the peace, disorderly conduct, and things that you don't typically associate necessarily with the resident safety and property risks that we talked about earlier in our housing guidance. So for sure, the fact that this lists some facially minor crimes, but then also has this very nebulous standard of disregard for the law and the rights of others is probably something that we would comment about. Another thing in this notice is that it talks about denying assistance for anyone who's on probation or parole for any conviction, and that is very broad because it's any conviction for any criminal activity. And probation, especially, sometimes people remain on probation because they aren't able to pay fees. Like, that's a very common hurdle that people have to cross. So to be able to say as a blanket statement from a housing authority that anyone who's on probation or parole will be denied assistance is probably problematic and overbroad. So there are actually good policies out there, and so we want to sort of talk about one from the Housing Authority of New Orleans, which has gotten some attention recently. It was recently passed and had been in the works for a number of years. And we've heard, I think, a lot of people talk about, what a great policy it is, but we actually want to break it down for all of you today so that we can see what are the components that make it really good, and can we advocate in our own jurisdiction similar policies to strengthen our local admissions policies.
Great. So I think I'm going to point out, provide a brief overview of policy, and then quickly kind of point out a couple of the things that we think are most important, and then we want to get to the other policy advocacy strategies so we can have at least 10 minutes for questions at the end. So the HUD policy, basically before making any decision to admit or deny, it's an application policy. Applicants are given an individualized review based on accurate information, including a notice and opportunity to be heard. So there are 2 steps to the HUD screening process. One is the policy identifies applicants with 1 or more criminal convictions that require further review, so everybody else is just automatically admitted. And then the second step is that the housing authority in their policy states methods and criteria used for the individualized further review. So the first really important point is that they use the language in the policy further review rather than denial. So it's just the use of the language alone makes a really big difference. Another important point is that there, as you can see, it's kind of hard to read on the slide, but the policy is a enumerated list, limited list of criminal activity. So as I said, everything else doesn't even require the further review. It's just these particular crimes, and even for them, they're designated, the time limits are designated. So within 3 years of conviction or 1 year of release, a handful are for any time, and a handful are for multiple convictions, for example, more than 2 within 10 years. So the look-back periods vary a bit based on the criminal activity. Most look-back periods, though, are within 3 years of conviction or 1 year of release. So another couple important parts of the policy is that the housing authority will not consider certain criminal activity. One, for incarceration for criminal activity other than those listed, so everything else. Arrests that did not lead to convictions, and in the HUD policy, pending arrest or deferred until adjudication. So that's something that HUD specifically allowed and it called out in the recent notice. And last, expunged criminal records. The housing authority will not consider. And another very unique aspect of this policy is that there's a panel that decides whether to deny or admit the applicant using an individualized assessment. So those folks that make it to the individualized assessment because they have one of those they have a criminal history is reflected in that chart, they go to panel, and the panel decides, and the panel includes a tenant representative. Not possibly someone from the resident advisory board, but it does leave it open, and I think that is really it's a unique and can be a really effective way to evaluate the totality of circumstances.
So another thing that is a positive is that it lists the possible mitigating documents. Which is important because I think for applicants trying to make their case, sometimes they're represented by attorneys and sometimes they're not. And so having this type of list to check against is really helpful for people trying to access housing. The other really great thing is that it lists out the different mitigating factors that the panel is required to consider. Again, to give people sort of a guidepost on what type of evidence they should provide to the panel to make their case. And it also requires the panel to explain any sort of factors that it considers that are different than what's listed. And so this adds to the transparency of the whole process and helps people understand if the reasons for their denial or eviction. And then just a couple of things to note is number one, and we didn't put this up here, but number one, they have really good provisions on written notices and all the information that should be on the written notice, and explicitly requires a copy of the criminal background check, which should be given anyway, and then also has a data collection component, and that is to sort of have the housing authority provide annual reports on the number of people that have applied and have been denied because of criminal background information. This information is lacking in a lot of public housing authorities and at HUD on the national level. And so holding housing authorities accountable is another important way to sort of make sure that people with criminal records have housing opportunities by showing how they have not in the past had those opportunities. So I think Deborah will walk us through the advocacy strategies.
Yeah, so we just wanted to end the presentation by mentioning other advocacy strategies. So we talked a lot about commenting on PHA plans. Maria Clara talked about the assessment of fair housing. Of course, there's also a local consolidated plan that advocates could comment on. But there's other advocacy strategies that we wanted to mention. So first, working with clients to appeal denial. So I think this is hard. I think you don't see a lot of these cases in part because people that are denied housing don't necessarily know they have a right to appeal in most circumstances, and we're talking about federally subsidized programs. And so just as an advocacy strategy to work with, if you're coming from a legal services office, working with clients to appeal those denials. So that would involve, of course, identifying folks that are going through the process and appealing. I mean, as a former legal services advocate, the organization I work for, we actually didn't do a ton of application cases. We focused on evictions, and I think that's somewhat typical of legal services. And it would be great to see a bit of a shift in that housing attorneys are accepting perhaps more of these appeal cases of denials and applications. Another important advocacy strategy is coalition building. So as we said throughout the presentation, there's a ton of momentum on this issue right now, and it's a great opportunity to build local coalitions on these issues. So with legal aid providers, reentry service providers, and grassroots organizations, and I think can't really promote any policy on this effectively without coordinating with some of the grassroots reentry organizations that have been working on these issues. And so it's a great opportunity to partner right now. And there's a lot going on again, I'm in California, so I can speak to some of the really interesting coalitions that are forming right now on this issue, and you know, grassroots folks reaching out to the city and you know, government officials, and it's just there's a lot happening. So there's also an opportunity to get the local HUD office involved that we wanted to point out. I mean, and partly as a result of all of this activity, it's a really good time to let HUD know that you're working on some of these issues, particularly with respect to those federal programs.
I'll make one quick note about the coalitions. I think the New Orleans, the Housing Authority of New Orleans policy would not have gone through without a very broad coalition in New Orleans. So that's really important. So the last couple advocacy strategies we have is that we want to talk about is litigation. Litigation is obviously something that we try to we try to work through with other organizations first and try to do advocacy, but sometimes you have a housing provider that won't budge. And so the Fair Housing Guidance has sort of opened the door for people to bring fair housing cases. But one thing that we want to note is that the HUD guidance is helpful in giving HUD's position on this issue or analysis of this issue, but it's by no means a settled area of case law. So this is an area where it's helpful to work with other advocates who are working on this across the country and strategizing on this. And so if there's any desire for information about that, you can email either of us. And then there is also supporting local and state and federal policy initiatives. Examples of things that are happening locally is that there are a lot of housing authorities, or there's a handful of housing authorities pursuing pilot programs, mainly geared at reunifying families. So allowing a current resident to add somebody who's coming home from the criminal justice system, adding that person onto their list and giving them some sort of probationary period. So supporting that, I think, is really helpful for that population, especially that's just coming home. And then also federally, Congresswoman Maxine Waters has introduced a bill to reform public housing practices or HUD-assisted housing practices in admissions and terminations and evictions as they relate to criminal records. And they are in the beginning stages of getting support on that issue. So there's a lot of ways to get involved, and we're really excited for all the different things that people can do in this area now that HUD has sort of taken a strong lead. And so I think then we have about 5 or 7 minutes per question. So I think Deborah might be able to read us the first question.
Yes, great. Okay, so I think I'm going to address the first question to you, and because it involves some of the fair housing work, the guidance that you spoke about at the beginning of the presentation. So someone had a question about how you'll have the statistical information and where you get some of this information. So I was hoping maybe you could just speak to, I know HUD in their Fair Housing Notice does present a fair amount of statistical information, but maybe speak to that a little bit.
Well, I think, I think they said that national data is okay, but I think that really to make a strong case, both, in the courts, but also to your own PHA, it's about getting the local data. And so sometimes it's getting data from I guess it also depends on what it is that you're looking at. It's like, is it an arrest record? You want to figure out like the local data from maybe the local police department or sheriff's department on the numbers of people getting arrested and what the breakdown is by race. Sometimes you can get state police records. So I think those type of law enforcement records and also correction records, which include people who are incarcerated, people who are under other types of correctional supervision, such as parole and probation, are necessary. And often those are going to come from the government entities. And then you also want to compare that, I think, to the data that you have on public housing, like who is in public housing, or what's the racial breakdown of the residents, of the applicants, of the people on the waiting list. So it's a lot of data. So that's going to be a big a big task for people sort of undertaking this type of fair housing work.
Great. Thanks, Marie-Claire. So I should start the question and answer by saying we got a lot of questions. So I apologize in advance because we're just not going to be able to get to them all today. We only have about 5 more minutes. But trying to pull out a couple of questions that are representative of some of the main questions that we are receiving. So the next one is going to be a reasonable accommodation question. So I'll take that one. Question is, does the reasonable, there are a bunch of questions about whether the reasonable accommodation would have to involve putting something in place that would prevent a crime in the future, and also what's the basis of the request, or is it's not simply to allow criminal activity. So I think that's right. The request would really to be allowed an exception to the housing provider screening policy. So whereas they might bar individual applying with a certain conviction, let's say, it would be a request to ask for an exception to that rule to allow the tenant, the applicant, to live in the property. And I do think you would have to provide some assurances to the housing provider that the criminal activity would not occur again in the future. I think that would be a really critical part of this type of accommodation request. So that hopefully generally answers the RA question. I'm going to go back to Marie-Claire because we got a bunch of questions about the look-back period. So a couple of people wanted to learn a little bit more, like where the look-back period starts and ends. And then I think this can look different in different policies, right? But and then someone had a question actually about the reference to your study. So I was hoping maybe you could just tell people where they can find the Shriver Center study, which is incredible. For those of you that haven't seen it, definitely take a look. When discretion means denial. Marie-Claire did an incredible job with this piece.
Thanks, Deborah. So we will be sending out an email with a bunch of links and resources. So we'll send that out. That'll be something that we send out to everyone. It's a good question about when the look back period, like what the trigger point is. The thing that was good about the Hanno piece was that it talked about release and conviction. So it recognized that there are two different types of trigger points. Most housing authorities do not indicate that, which can be very frustrating for people who are applying. I will say that most housing providers that I have seen, if you press them on it, they will talk about the latest involvement with the criminal justice system, which will usually be the release date. But if it's ambiguous in your jurisdiction, that's definitely something to flag. Unfortunately, I think we're sort of at the end of our time, and Deborah and I are really here to try to be a resource to people. So I think, and I'm speaking for her, I think we're going to really try to go through the questions and answer them for people, and maybe even make something that's semi-public so that people can see the answers to people's questions. But we are definitely committed to answering everyone's questions, so please feel free. I have the contact information here. You can email either of us, and if you have additional questions, we are more than happy to answer them and to be here as a resource, because I think there's a great potential for change in this area, especially in the upcoming year as housing authorities go through their plans and go through the AFH process. And so we want to try to maximize this opportunity while we have it before us. So I think we'll, with that, I'll turn it over to Amanda for some closing remarks.
Sure. Well, thank you so much, Marie-Claire and Deborah, for that really informative presentation. The Shriver Center would also like to thank the Butler Family Fund, Jim Mabey, and the John D. and Catherine T. MacArthur Foundation for their financial support of this work. And I will remind everyone that within the next few days, everyone who registered will receive a follow-up email. That email will include a link to a web page where you will find a recording of today's webinar, a copy of the slides, and links to some additional resources, including many of those that were mentioned during today's webinar, and possibly, as Marie-Claire said, some sort of responses to the questions that were submitted that we didn't have a chance to get to today. Thanks again to Deborah and Marie Claire, and to all of you in the audience. Thank you again for joining us today.